And another thing, these, supposed to be two people not neither represented by an attorney in court, right? But she is presenting all these papers. She goes into court and she provides a book that was, honest to God, it was that thick, and she had it labeled "My Days of Hell in Hillcrest." Okay, and when I went into court, I says, "Can I have a copy of that? Of these accusations she's handing you regarding me?" And he says, "No, she doesn't have to do that." He says, "Well, do you have copies of everything you're going to present for her?" I went, "Yeah, I sure do." He said, "Well, that's not required, Mr. Brailer." Well, isn't it preposterous that a person can sue us in small claims court where we're not allowed to have an attorney, but they can go in with a prepared list of bullshit, prepared, written, directed by one of these attorneys, and present it to the judge, and he's going to then read it, and then when you go to protect yourself from in this case of a litany of lies, he is going to actually represent her case. This is preposterous. It's preposterous. We cannot allow these fucking wolves to decide how justice should be issued. Our Bill of Rights already said how, and these guys are not doing it according to the rules.
Okay, so the reason they did this is because once you get one attorney to screw you, and the best way to do that is make sure the person you're screwing isn't there, which is what this accomplished. Once you get one judge to screw you, the other judges are just going to back each other up, and that's collusion and that's conspiracy. Okay? That's what that is. Anyway, 1st, 2004. The change was not filed until 2 days after the judgment on October 21st. So she goes in there, while she's at court probably. You didn't get the notice of judgment until after November 2nd because it had to be remailed on November 1st. The court still had the phony address. This court's file contains the proof of service made by Moore's attorney showing a date of September 16, 2004 and the address of 1726 Pennsylvania. And he had already mailed me stuff to my correct address. So there wasn't a mistake here. This was intentional. Okay. So anyway, we go in there and we, you do a notice of, a motion to vacate, and we vacate it.
Oh yeah, it's a good thing I have this sense of humor. Yeah, so we go in for the vacation here, and I'm presenting this argument up front. I've got this copy of her previous testimony, which is just a fucking litany of lies, and I've got this heading at the top, my allegation that there's a conflict of interest for this court to try this matter because it involves a fraud, and this judge is going to jump right in and aid and abet it, and I'm saying that this misaddressing of my thing was intentional, and the judge goes, "Well, I know Mr. Curry, and I don't think he would do that," and hello, he's like a person him personally. He wouldn't do that. Oh, well, what I meant is not intentionally. Horse shit. And not only that, but after I provide this argument, and the case gets the previous finding gets vacated, who do you think comes in as the judge to try the matter? But this very judge that vacated it, that expressed that he knows Mr. Curry wouldn't do such a thing. Hello?
And we retry it. Now the beauty of this is, for $10 you can buy an audio tape. An audio tape is not sufficient. What I really need, and what every citizen needs, is an actual videotape of whenever you're before a judge, whenever anybody is making false accusations against you under the Constitution and Bill of Rights, is that courts shall be of record. Okay, right? This court you can order an audio tape, which is not good enough. because I'm having to sort of make a videotape, because people aren't going to read your presentation to the court in some writing, and that's what they want. They're going to have they're not going to listen to an audio tape. You've got to make it visually stimulating also. It needs to be audio visual, and what I'm saying is we need audio visual tapes in all of our courts, and at every ex parte meeting, any in chambers meeting, we need a camera on the judge, so you can document to the public how corrupt our courts are, and that will put a stop to this. And you have to ask her, when it's that simple to do it, why hasn't it been done? Let me tell you why it's done. Entire legislative and executive branches is composed of what? Attorneys. They've all gone through the law schools, as I've already documented, and from the day they get out of law school, they understand this collusion to aid and abet the criminal activity of their kind in order to feed their kind upon us. So when we have the retrial of the matter, I transcribe the tape of her accusations made at the previous trial, and I have this ready. And she gets up there at what's now going to be the retrial of it. Not the retrial, it's the retrial, but the first one was set aside. And here's how she starts out. Well, she goes in. First of all, she makes it a point of letting the court know that she is represented by this attorney. In case you've forgotten, I'm the one that Mr. Curry called you about. Okay. She goes in this thing. Blah, blah, blah. Anyway, what she says is basically that she was evicted that I evicted her the day after she refused to provide me sexual favors in exchange for doing work. Okay, that was probably the most noxious of her accusations. And then it was, of course, that I didn't return a damage deposit, right? So I start right into, right to present my relative impeaching evidence. Now, she says, it goes on. She says, and I asked the other tenants, how do you get Mr. Brailer to do any work? One said you have to point a gun at him. The other said I do my own work in order not to get on Mr. Brailer's bad side. Okay? And in response to that, I throw out this list. Now, she says, she's going to teach me how to prioritize. So in court, I present this list. Okay? And I point out to the judge, it's 7 pages, 50 lines per page, and these are all the jobs that I did for Mrs. Moore. That's what this is. This is a list of jobs done for Mrs. Moore. And then on each page, the first column, this column right here, the third column, is the date it was requested. The first column here is the date it was finished. The center column is how many days it took me to do the job after you requested. And you'll notice most of them are 0, 0, 0, 1, 0, 19, that was the sprinklers in the valley, 2, 12, 4, 5, 0, 12, 1, 2. 350 jobs I did for her. She had just in effect said that I had never done anything for her. She had to ask the other tenants, how do you get Mr. Brailer to do anything? Here's 350 jobs, and the judge takes this and he goes, now Mrs. Moore, did he do this? And she goes, oh well, yeah. And did he do this? Yeah. And down the list, a little more. Yeah, yeah. But he didn't do the thing. He goes, okay, but Mr. Brailer, you didn't do the things on the list of things that you said you were going to do. Did you do all the items that were on the list of things you said you were going to do in your initial rental agreement with her? Well, on the initial rental agreement, there was a jacuzzi in a backyard, which was not working at the time, and I told her that the first thing I had to do was level up the platform under it, because it had been put in on a platform with such a rake that just to fill the thing up it would be running over one side a bit. So I needed to level it up, and I did that. We moved the jacuzzi off, we leveled it up, and on moving it back in, we accidentally broke the jacuzzi. That's what happened. Okay. And we're talking about breaking the pipes underneath the jacuzzi, and I was going to have to figure out how I was going to, repair that plastic damage to the plastic piping.